Ladies and gentlemen, today I am going to talk about another fancy Latin phrase used in international law, Jus Cogens. Jus Cogens simply means a crucial rule that nobody can ignore or break. Imagine you and your friends start a conversation club, and in order to make the club successful, you all agree on one particular rule that everyone must follow. It is that everyone gets a chance to speak during club sessions without being interrupted or bullied. To ensure that everyone's voice is heard and respected, it's a rule that every member of the club must follow, no matter how much they may disagree with someone else's ideas. Similarly, in the world, there are certain really important rules that all countries have to follow. These rules include things like not starting wars without proper reason, not discriminating against people because of their race, religion, color, sex, or other things, and not taking away people's basic human rights. These rules are incredibly important, just like the rule in your conversation club. And no country can say that we don't want to follow these rules. They have to follow them to ensure peace, fairness, and respect for everyone. So, Jus Cogens is like the most important rule in your conversation club that everyone has to obey. And in the world, it's the most important rule that all countries have to follow to create a better and more equal world. Now, before moving further, I just have a small request to make that please like my videos and subscribe to my channel. I would be really grateful. Coming back to Jus Cogens, law dictionaries define it as a mandatory and non-derogable rule of international law that is accepted and recognized by the international community. It is also called a peremptory norm of general international law. Remember, it is peremptory and not preemptory. I see people calling it as preemptory all the time, and that saddens my heart immensely. Peremptory and preemptory have completely different meanings from each other. On the one hand, peremptory means something that is final or absolute or conclusive, whereas on the other hand, preemptory means something that is done without providing an opportunity or done with a premeditated mind. It is also worth knowing that Jus Cogens is considered so important that it also finds mention in Article 53 and Article 64 of Vienna Convention of Law of Treaties 1969. We also know it as VCLT. Article 53's heading is Jus Cogens, and it says that a treaty is void if it contains any provision that conflicts with a peremptory norm of general international law. Basically, Article 53 is like a rule book for treaties. It says that if a treaty goes against a really important rule that all countries have to follow, then that treaty is considered invalid. It further provides that those important or peremptory norms can be modified or amended only by a subsequent norm of general international law having the same character. Thus, a Jus Cogens rule can be replaced only by another Jus Cogens rule. It cannot be replaced by a rule that does not have the same status or is voluntary in nature. Further, in the same breath, Article 64 of VCLT explains that if a new Jus Cogens rule emerges, any existing treaty which is in conflict with that norm becomes void and terminates. The bottom line is that if a new Jus Cogens rule comes up after a treaty is signed, then that treaty might need to be amended to comply with the new Jus Cogens rule. You see that Jus Cogens has a very special status in international law as it overrides and trumps the treaty that contains a rule to the contrary. And it is not just the provision that is conflicting with the Jus Cogens rule that would be void. The entire treaty would be rendered void and terminated. You can think of it as Lakshman Rekha. If a treaty crosses the Lakshman Rekha, it will be immediately wiped out. To explain further, I'll give another example. Imagine two countries, A and B. They enter into a treaty for cooperation in trade and security. There is one provision in that treaty that permits slavery and forced labor for manufacturing goods for each other. Since slavery and forced labor are already prohibited under multiple international conventions, the existence of any such provision in the treaty permitting slavery would render the entire treaty as void and inoperative. So today you must be thinking that Jus Cogens must be widely accepted among the scholars of international law. And you are right. Lauterpacht says that the concept of Jus Cogens operates as a concept superior to both customary international law and treaties. However, you would be surprised to know that this was not always the case. Earlier scholars like Hugo Grotius and Vettel relied heavily on the distinction between obligatory law, jus strictum, and voluntary law, jus dispositivum. But with time, Jus Cogens has gained widespread acceptability and status. So today, the voluntary law is at a lower pedestal than the obligatory law or the Jus Cogens rule. Jus Cogens has also been discussed in plethora of international cases such as Paulo Naira French-Mexican Claims Commission case of 1928, individual opinion by Judge Schuking of Permanent Court of International Justice in the year 1934. It is also called as Oscar Chin case. Then US versus Meta Ballesteros, a 1995 case, Congo versus Rwanda 2006, and Kosovo advisory opinion of the year 2010. There are many other case laws as well. That was all about Jus Cogens. There is a lot to know about this doctrine and I have barely scratched the surface. To know about it further, I would suggest going through case laws and standard texts like Malcolm Shaw or Stark's International Law. Thank you and see you next time.